Yes, any mention, please do it fast.
Please, Your Lordship. Lordship, I beg to make a mention of item number 13, Your Lordship. I believe this matter may be listed after 2 weeks, Your Lordship.
This is for protection of
Yes, Your Lordship. Lordship, we're still awaiting instructions, Your Lordship. Awaiting instruction, Your Lordship. 2 weeks' time may be given, Your Lordship.
instruction is required here just to produce the record. Who's for the petitioner?
Mr. Jha, Your Lordship.
Yeah. Have you informed him?
He's not around, Your Lordship.
Let the matter be called up.
Obliged, Your Lordship.
Your Lordship, I beg to make a mention of item number 15, Your Lordship, if this matter may be taken up after 2 weeks.
What is this matter about?
This is with regard to suspension, Your Lordship. Two weeks, Your Lordship.
On pre-meet with the petitioner? This is matter up to 2 weeks.
Your Lordship, similar prayer for item number 11. You have informed the other side, Your Lordship.
Yeah, for the
private respondent.
who's the principal respondent here?
The district council, because the inquiry report is under challenge, whereby I've been exonerated from the charges.
On pre-meet with the petitioner, not objected to by respondent. This is matter up to 2 weeks.
Highly obliged.
Please, Lordship. I beg to make a mention for item 16, Your Lordship. So I'm praying for 2 weeks' time, Lordship.
On pre-meet with the petitioner, this is matter up to 2 weeks.
You're blessed, Lordship.
I beg to mention item number 12, Lordship. Your Lordship, I am praying 2 weeks' time to file our written argument, Lordship.
I have a serious objection on this, my lord. They have already filed the written argument, my lord. Now, today we were supposed to file the written argument. Moreover, my lord is
Have
friend.
you,
Yes, ready, my lord. We are supposed to submit it today, my lord. He's ready, my lord. He's with me. My lord, moreover, my lord, a serious allegation has been made against the district council court, my lord. I have examined the record, my lord. They was there, my lord. Their Hazira is there, my lord. They say that on a particular date, order was passed in their absence behind their back, and they have not, the date was not informed to them, my lord. Hazira is there, my lord. Their lawyer signature is there, client signatures are there.
that has been
The argument is over, my lord.
that has been stated in the pleadings.
Yes, my lord. And they have enclosed a letter from the Tura lawyer, my lord, who says that on a particular date, there was no hearing. The matter was heard. They have filed the written argument. Private respondent has filed the written argument, my lord. We have decided the matter.
Records are required.
Record, I am going to enclose those, my lord. Enclose those order sheet and the Hazira that they have filed, my lord. I
think the record would be.
Yes, record is also there, my
In
lord.
the record, the original would be.
Yes, my lord, is there.
It's there.
Yes,
You
my lord.
produce the record.
Yes, my lord. This matter has to be decided, my lord.
Lordship, on the last occasion, we have prayed for the written argument, Lordship. And the
No, my
prayer
lord, they
is
have
allowed.
already filed, my lord. They have already filed.
Yes, you may have paid, but if you have already filed, then what's it?
Whether that prayer was allowed, my lord, that prayer was not even allowed, my lord.
Then the letter may be called out, Lordship.
You check the records. Check the records and see. If you have filed your written argument, then there's nothing more.
Letter may be called out, Lordship.
Fine.
My lord.
At the end of the word, Lordship.
On daily list, item number 1.
So who has filed the counter and who has not?
here, Your Lordship, after the deletion of some of the respondents, Your Lordship, even the petition again is defective because, Your Lordship, the petition which the order, the proceeding which has been taken place in this council is of another village. They are again annex a village which is in connection with WPC 188. Your Lordship.
Okay, you're talking about this 426.
Yes, Lordship. Here again the petition is defective. When I try to draft the affidavit, it's again at page 90. Lordship.
Page 90 is the impugn order.
This is the petition which they
Petition.
the proceeding, Lordship. This is again is connecting. So this petition is connection with the village which is in item number 8, Your Lordship, today listed item number 8. So I cannot. The issue is
And item number 8
is
the
of
papers,
the village.
the papers in item 8 is pertains to this. There's some mix up there.
Yes, Lordship. The order challenge is of Maukuduk village. They have annexed the this proceeding which takes place of the village which is listed in item number 8, WPC 188.
You check the papers.
We will do the necessary correction, Your
We'll
Lordship.
take it up tomorrow.
Your Lordship.
All the related petitions.
Your Lordship. In fact, we have annexed in the additional affidavit, Your Lordship.
So the additional affidavit has been not taken into consideration because, Your Lordship, they have deleted the name, separate petitions, separate orders have been challenged.
We'll do the necessary replacement, Your
This
Lordship.
is a new matter.
Yes, Your Lordship.
Lordship.
From 5 to
So tomorrow,
Your Lordship, give us 2 weeks, Your Lordship. We'll do the necessary replacement.
and you have to first ascertain as to what is required to be done.
Your Lordship.
Then you have to make a prayer. The court will allow you. Then you can do the whatever is required to be corrected.
Your Lordship.
The matter will come up after 2 weeks.
According to Your Lordship.
Your Lordship,
If not tomorrow,
1 week, Lordship, because the
day after
petition,
tomorrow.
Lordship, 1
See,
week,
what
Lordship.
is required here, even if the matter comes up tomorrow or day after tomorrow or whatever the case within this week,
Your Lordship.
what is required is only for you to point out to the court, as Mr. Karyam has pointed out, that this is the defect that we have noticed. Or if there is no defect and you continue to hold your stand, that will also be taken into account. And then if any rectification is required to be done, the court will allow you.
Your Lordship.
That
Yes.
maybe after 2 weeks or so.
Your Lordship.
So we'll take it up day after tomorrow.
Your Lordship.
What is there?
Item number 1, 5, 6, 7, 8, 9, and 10. Your Lordship.
That's right. Day after tomorrow. That is, Mr. Karyam, you're saying only with regard to item number?
Item number 1.
Item number 1. But Your Lordship, the petition which other matters I just received from Friday evening. When I checked, Your Lordship, I have detected only one defect, Your Lordship. I cannot, maybe 1 week, Your Lordship, this matter 1 week. Then I'll inform what necessary, all matters.
On pre-made parties, list is matter after 1 week.
Of Lordship.
In the meantime, the other respondents also are here. If you find that everything is okay, you file your counter.
Actually, Lordship, on behalf of this council, we will not file any affidavit.
Item number 2.
Okay, jom hipa.
Ketu je ni.
307.
Lordship.
Yes, my lord.
Lordship, that is the case diary, Your Lordship.
Yes.
If Lordship kindly come to the statement of the victim, Your Lordship, Lordship will find it. It has been flagged, Your Lordship, at page 78 by a flag. Okay. It's a cream flag, Your Lordship. Statement of the victim, Your Lordship.
Yes.
This is the statement, Your Lordship, you see. See, can you see, Your Lordship, his statement? And I saw one stone on the dashboard of the car where Shri, that means the applicant, Your Lordship's son.
This one.
Then, Lordship, somewhere in the middle, Your Lordship, Shri Ban Miki Suna, that is the lick, alias Lick, Your Lordship, assaulted me on the head with a stone he grabbed in his hand, and I became unconscious. Lordship got it. He got that statement.
Yes.
Then later, after some time, he took me to my workplace at Halaskain by the said vehicle. On reaching, and I did not remember how I got out from the vehicle because, Your Lordship, he was given with drinks, Your Lordship. I could not remember.
Oh, these, okay, now I remember. These are those friends.
No, Your Lordship. Lordship, it appears that they were friends, Your Lordship. They are friends, Your Lordship. This Rajesh Sari, Your Lordship. He is the victim. He is the victim, Your Lordship. Then, Lordship, can you see? To my workplace, on reaching at my workplace, I did not remember how I got out from the vehicle, whether myself as they took and they took off the vehicle. However, I could remember and saw with my own eyes that one Assam registration number pickup was coming slowly from Shillong side, and I thought that I would cross the road after it had crossed, but as the said pickup was approaching to us, and upon reaching at us, I was pushed by someone from behind. That means, Your Lordship, by his friend only, Your Lordship. But I was injured from the part of the head at the time when she, Lordship, pushed, and I fell against the said pickup, and it stopped immediately. And hence, I was not hit by the said pickup, nor did I got injured from it. But I was injured from the part of the head at the time when Shri Banmiki Suna alias Lik assaulted me. Thereafter, they laid me in front of the gate of the building where I was employed and fell asleep at the gate and did not know what happened next. So, Lordship, the statement of the victim, Your Lordship, correctly stated. It's very clear, Your Lordship. That is it's a pre-plan, Your Lordship, because the stone was already there in the dashboard of his car, Your Lordship. It's a pre-plan, Your Lordship. For what he kept that stone on the dashboard, Your Lordship? Because he hit him with that stone only, which he kept in the dashboard, Your Lordship. Then, Lordship, kindly come to page 11, the statement of those people who it's a pink flag mark, Your Lordship. Kindly see statement of the dhaba cashier, Your Lordship.
Yes, sir.
Lordship, Lordship will.
Just a moment.
I'm sorry, Your Lordship. Lordship, it has been paged by a pencil, Your Lordship. Lordship will find it at page 11. Yes. Lordship is with me. Lordship, kindly see that
On being stated, she stated my name and address mentioned above is true and correct. I was working in Rajasthan Dhaba since so and so. That on 26 at around I reached this Dhaba and sitting and looking at the customer of the Dhaba. And on the same night at around so 4 people come to the Dhaba and ask the food, and according the hotel served them. Thereafter, one person name not entered in the Dhaba and assault one person name not known to him. Lordship, because there were 4, Your Lordship. The victim plus the bail applicant and 2 of his friends. 4 people, Your Lordship. Then, Lordship, kindly turn to the next page, Your Lordship, at page 12, Your Lordship. The statement of that people working in the Dhaba, Your Lordship. They said the same thing, Your Lordship.
No, I think even the petitioner has not denied that there was
yes,
fight.
My lord. Scuffle, of course, we don't deny.
Yes, Your Lordship.
The only fact that this court would like to ascertain is that aspect of the, where the allegation was that
he was hit by the
victim was hit by
Lordship,
the
the statement of the victim is very clear, Your Lordship. It's very clear, Your Lordship. The statement of the victim is very clear, Your Lordship. So, Your Lordship, in view of this clear statement of the victim, Your Lordship, that it was the bail applicant who accepted him, Your Lordship, my humble and respectful submission, Your Lordship, and the bail application may kindly be rejected, Your Lordship.
My lord, if I may make my submission. My lord, in addition to what I have submitted earlier on the last occasion, I would like to make another my submission on 3 aspects. First of all, Your Honors, on the first aspect, FIR I have already submitted 2 versions. For the first part of the version, it has been investigated regarding the scuffle, regarding the incident which has been taken place at Dhaba. No doubt it has been investigated, and I also didn't deny that there was a scuffle between me and the victim, my lord. And thereafter, second part of the FIR, there was an allegation. Categorically, the informant also has stated that he was hit. My lord, if I may take my lord to page 13, 14, and 15, my lord. These are the documents of the offending vehicles which hit or that hit the victim on that night. This document, we brought it before the District and Session Court also for consideration, but it has not been concerned. Due to the investigation, which was not properly done by the officer, this part has not been investigated till the date when we move an application. And it seemed till today also, this part has not been investigated by the police. And on top of that, your lordship, had the IO investigate this part, clearly it has been seen from the CCTV footage of the Joy Civil Hospital Yelong, whereby it was the vehicle that hits the victims who carry him and admitted him to the hospital. If that part has been, if this part was investigated and the CCTV footage of the Joy Civil Hospital, clearly it will be seen, right?
See, Mr. Suna, that is true.
Yes.
That's true. Even the victim has also admitted that there was a vehicle with Assam registration number.
Yes.
To that extent, he is clear.
Yes.
But you fail to notice that he said
I was pushed, but he has
was
not
pushed. Number 1.
Yes.
And number 2 is that vehicle did not actually hit him. It stopped. It stopped before hitting him. And the main cause of his injury was due to the assault by you. That was his statement.
Yes.
So that has to be taken into account. As far as the investigation is concerned,
Yes.
the case is under investigation.
Yes, Lordship. It's going on.
The police, the IO would do the needful. Now that this fact is known to him, in fact, now that he has, recorded the statement of the victim, then he'll look into that aspect.
Secondly, my lord, not only the statement of the victim, statement of one of the friends which go along with them, Toki Clem, it has been recorded. Statement of the accused also, it has been recorded. That may also be looked into, my lord. And then second aspect, my lord, I'll come to the cooperation part of investigation on the part of the victim petitioner. My lord, following the interim order which has been passed by the district and session court on 16, 17th the accused duly appeared before the IO. On 18, his statement was recorded. He has been taken to the place of occurrence and then had been taken to the hospital for medical checkup, which is a part of investigation. So, my lord, and on top of that, on the final day of the hearing on 22nd, when the IO produced a CD before the district and session, categorically has made when he was asked whether he required custodial interrogation of the accused. The IO fairly stated in his statement before the court that I did not need. It was, I have mentioned in my petition that he did not require further interrogation of the petitioner since the accused has already made his statement, and moreover, most of the formality has been done.
You have stated that in your petition?
Yes.
Para?
Para 17. If I may read, my lord, that further on 22nd 5, upon receiving the case diary from the concerned IO, and after hearing the submission of the learned counsel for the party and verbal statement made by the IO before the court, stating that he does not require the physical interrogation of the accused, since he has already given his statement and fully cooperate with the investigation during those 2 days when he was asked to appear before the police beat house in terms of the interim order dated 16/5/2024. The learned district and session court deferred the matter on 28 for passing the final judgment. This is the statement of the IO before the.
Yes, Mr. Shula, what do you have to say?
That fact, Your Lordship, was not recorded by the learned session judge, Your Lordship. If that is the statement is true, learned session judge could have recorded in the judgment, Your Lordship, in the order rejecting the bill application, Your Lordship, because the court records of the learned is conclusive, Your Lordship. There is no such observation made by the session judge. How can we believe, Your Lordship?
That is what is required. You see,
Lordship, otherwise, if there is really that statement made by the investigating officer before the learned session judge, Lordship, could have.
Exactly.
But there is no thing as such, Lordship.
What my lord will
Lordship, in my humble and respectful submission, I believe the records of the learned session judge, Your Lordship. The record of the learned session judge is conclusive, Your Lordship. There is no such statement, Your Lordship. This is all afterthought, Your Lordship. Afterthought statement.
I beg to refute, my lords.
It's all concocted and afterthought, Your Lordship.
Have you annexed this order dated 22/5?
22/5 I have not. There's no orders, they simply defer the matter on 28. That's the only order.
Because you say in your vermin, you say that on
only extend the interim order.
No, after hearing, here you said after hearing the IO and the submission of the parties, so they were on that day, the IO did say that he is not required for custodial interrogation. So that should have been recorded in the order.
Yeah, it should have been recorded, but it has not. To be very fair, my lord. Yes. But the fact remains he has admitted
Lordship,
before. He has
I'm sorry, Lordship, I did not please the status report. Otherwise, Lordship, the IO would not have given us this status report, Your Lordship. And Lordship, kindly see the last sentence of the report of the IO, and need to be arrested the accused person. If we could have made that kind of statement before the learned session judge, Your Lordship, the IO would not have given this kind of status report, Your Lordship. This status report is 10/6, Your Lordship.
In my humble and respectful submission, my lord, if the IO further required him, he has to have justify his ground. What are the reasons which still required him, despite the fact he has all along cooperates? I may say with the. Now, my lords, pursuant to the order passed by this honorable court also on 6/6/2024, the petitioner duly appeared before the IO, and he has communicated the order of this honorable court. And he offered himself that if I'm required to interrupt, I'm ready to answer any question. But it has not been asked. The IO simply said that if we require your interrogation, we will inform you. But till date, it has not been. meaning thereby that the IO are almost no longer required the further interrogation of the petitioner, my lord. Yeah.
This status report is dated 10/6.
10/6, Your Lordship.
Means yesterday.
Yes.
As on yesterday,
Yes.
he is still required to be.
But as on that day which the petitioner appeared, yes.
I think on the basis of the statement of the victim, this court will dismiss your petition. But I will give you an opportunity to file a fresh application before the trial court, wherein the trial court would have would direct the IO to appear before the court to clarify the situation as to whether he is required
or not for custodial interrogation, Your Lordship.
Because you see, it may not be proper to summon the IO before this court.
This court,
but as far as the trial court is concerned, I think he can. What is the stage of the case?
Lordship is going on, Your Lordship. Even the driver
investigation is going on.
Lordship, even the driver has been summoned, Your Lordship. Has been summoned.
I'll directly you file your petition. What you can do, if you want me to decide on the merits, I'll decide on merit. If you feel that you want to withdraw this with liberty to file a fresh application, I will do that with a remark that the IO is required to appear before the court. Because there are conflicting statements. You see, you are saying one thing.
Yes, my lord.
The IO report is saying another thing. Whom do we believe? Except if the IO is present before the court and he will stay. He is the master of the investigation.
My lord.
Lordship, under London Session Judge, he is the master of his own proceeding, Your Lordship.
Exactly.
He's a master, Your Lordship. He was there, Your Lordship, face-to-face interaction, Your Lordship, but nothing has been reflected in the record, Lordship. Lordship, yes.
We have live streaming in this record.
Lordship, I'm really not aware, Your Lordship, whether that kind of thing is there. I think it should be there, Your Lordship. I think it should be there.
We can always confirm.
Yeah.
Even proceedings before this court.
I think it should be there, Your Lordship. I'm not really aware, Your Lordship, so far this report is concerned.
The opinion of this court is your petition is to be dismissed. The matter is very serious. The statement of the victim has to be taken, into account. Apart from that, as far as the investigation is concerned, if the IO feels that you are not required, let him say so.
Lordship, yes.
Do you want to withdraw this with liberty?
My lord, that liberty may be given to me.
I'll give you the liberty. That is your privilege.
My lord.
In course of hearing, the AAG has produced the copy of the case diary and also the status report filed by the investigating officer. The status report dated 10/6/2024 filed by the investigating officer. However, the parties would impress upon this court that the merits of this case may not be looked into, and that the petitioner will be allowed to withdraw this petition with liberty to file a fresh application before the court of the Learned Session Judge is West Chanty Hills, Joy. It is also the prayer of the Learned Council that while considering the said application, the Learned Session Judge may summon the may call for the personal appearance of the IO for clarification on certain aspects of the investigation. This submission was not objected to by the learned AAG. Accordingly, on pre-made, the same is allowed. This petition is hereby dismissed as withdrawn. Liberty sought for, as indicated above, is also granted. Petition disposed of.
Oblige, Your Lordship.
Yes,
Lordship
will return.
will take back, Your Lordship, along with the status report, Your Lordship. Lordship, may kindly be reflected in the order.
CD, copy of the CD is returned.
Oblige, Your Lordship.
Item number 4.
See, Mr. Suna,
records are with me, my lord. This is the matter where the matter was heard in length, and we have prayed for filing a written argument, my lord. And my friend has already filed a written argument, which is a matter of record, my lord.
Lordship, the earlier order, I have stated in the order also, I was still allowed to file it because the order also stated parties are free to allow, free for filing the written argument.
My friend has already filed a written argument, and this honorable court was, my lord, pleased to grant him permission, my lord, to submit other documents also which he has not relied upon in the writ petition, my lord. His written argument is already there, my lord. Now, on the last occasion, my lord, a serious allegation has been leveled against the district council court, my lord. Now, my lord, if my lord may kindly see, this is the written argument, my lord. I will supply a copy to my friend also. Now, my lord, may kindly come to page number 12, my lord.
May I submit, my lord, before my friend start, lordship. Just earlier occasion, when I filed my rejoinder, the written argument, I also have enclosed some document, whereby my learned friend has objected that document should not be treated because he has filed. But now he also is coming with another document which they have not.
It is a record. I am going to place the record.
Even on my whatever the document which I have enclosed, even in my the written argument, it is also on record. Now, in this affidavit, in this written argument, they have filed the affidavit in opposition against the petition which I filed. They have not enclosed to this. Now, here what I'm saying is, when I have filed my written argument along with some annexures, they have strongly objected.
My lord, these are order sheet I am enclosing, my lord.
Even
order sheet.
Whatever may be the order.
How can he say that?
But you see, Mr. D,
my lord,
you pause for a moment,
my lord,
and consider what entails a written argument to be filed.
Yes, my lord.
A written argument means only on whatever has been submitted.
Yeah, exactly, my lord. Exactly.
A gist of it is to be produced in written form for
exactly, my lord.
For
My lord has done
for the convenience of the court.
Yes, exactly, my lord.
Number one.
Yes.
Number two is whatever has been is on record, materials on record, including annexures, whatever.
Yes.
That can be referred to.
Yes. That is what we are referring only.
See, now, in the written argument, you cannot introduce new facts.
No. Yes. Nothing new, my lord. Nothing new. I am countering what is the allegation that he has leveled.
But he is
now,
saying
this is the order sheet. If, my lord, I have just xeroxed this order sheet and I put in my written argument for the ready reference of this honorable court, how he can say these are not part of the record?
No.
Can I not produce the record also, my lord?
Yes, record is record to produce. That is so that.
He is saying, my lord,
no, but
procedure has not been followed.
No,
I am raising those record to show that the procedure has been followed. Now, let him object, my lord, because he will have a serious objection. Because now, what I'm
Mr. Sama, even at this point of time, you can have a look at the records.
Yes.
There's nothing wrong with it.
Yes.
Just see if it is wrong or right.
Because I have the documents which I am referring, my lord, from the record, my lord. This is what I have enclosed.
That is.
If that is not permissible, my lord, then.
But as far as you are concerned, you see, if you said you have filed your written argument, you have also enclosed some documents, whatever. Yes. If they are also connected with, the pleadings.
Yes.
As far as your petition is concerned, then the court will allow.
Earlier, what I have enclosed, I have just enclosed the petition which I have placed, which I have filed before the EM court. It is also on record, but they are rejecting. No, now
who am I to reject, my lord?
It is already on board.
My lord, who am I to reject?
No, at the time of argument, they said no. Now he's bringing another new document. That's why I said
that is for the. You see, that is.
Court to see. Secondly, court also have allowed me to file another like a written argument. You can file it. There is no bar. I said I will file it, but he's objecting to that.
Have you filed it?
Actually, yesterday, no, lordship. What honestly I'm speaking because my laptop got spoiled yesterday. I supposed to get it printed. Yes, this is actually this is unofficial subpoena. I can.
Can you do it tomorrow?
Definitely, I can do it tomorrow.
Yes, my lord.
Definitely.
My lord,
This hearing is already done. Only to submit the.
You see, I'll allow you. You see, whatever.
Yes.
You see, I'll allow you full opportunity to place your case, so that there will be
more clarity, my lord.
Yeah, so that there will be no accusation against the court or anybody else.
Yes.
You do it.
Yes.
But finally, you know very well, the
Yes.
court will decide on the basis of the materials on the court, the facts. As
Yes.
far as the record is concerned, since the court has called for the records, and the records have been called for
Yes.
and have been produced. Rather.
Yes. But now he wanted to again want to argue the matter.
No question of argument.
My lord, my friend should allow me to speak, my lord. Serious allegation has been leveled against of us.
That you have pointed out in your
No, my lord. That is what
And
I
in
am
your
placing the
argument
record.
In your argument also you have
Let him finish, my
Mr.
lord.
D, have you pointed out in your argument?
My lord, that is why my lord record has been called. I have to point out.
You just flag whatever is.
Yes, my lord. That is what I have flagged, my lord. That is what I am pointing it out.
Do that.
There should not be any further argument.
Now, my lord, he will dictate me, my lord. This is very unfortunate.
We are not saying about argument, Mr. We are only on the issue of written argument.
He is afraid, it seems,
No.
that he will get exposed.
No.
What he has written, my lord, here.
Doesn't matter. That is.
No, my lord. But my lord, I have been instructed to apprise this honourable court, my lord.
Your argument will be noted.
My lord.
Your
My lord.
argument will be noted. Records will speak for themselves, and the court will decide.
Yes.
Because, my lord, there is a
Either of
perjury.
the party is not satisfied with the decision of the court.
yes,
they can
yes.
always go up.
Yes, my lord.
That is
Exactly.
always, that
Yes.
option is always there.
Yes, my lord. My lord, only there is a perjury. That is why my learned friend is not allowing me to open that record, my lord.
Because of that.
Why I am saying so, my lord? My lord, may kindly consider 2 minutes. Give me 2 minutes, my lord, because I have been instructed to inform this honourable court, my lord. Because there is always an allegation that we are biased. Yesterday also one matter, my lord, we has been alleged that we are biased, my lord. Now here also a serious allegation has been leveled against of us, where they said, my lord, this is a certificate which has been issued by the local council from Tura. Now they say this is a certificate that the present appeal final hearing was done on so and so date and fixed on 26/3/2020 for orders. However, due to COVID, there was a lockdown and all, my lord. Now, my lord, may kindly see the allegation, the writ petition, that there was no hearing. He has filed a written argument, my lord. His written argument are there. He has filed an hazira on the final day of the hearing, my lord. Then the matter was fixed for orders. There was a COVID. Subsequently, a particular date was directed, my lord. Both the parties appear. As I have shown, my lord, from the certified copy, that on that particular day he was present in the district council, my lord. But, my lord, this certificate and the allegation which has been leveled, my lord, it is unfortunate, my lord. We are sitting there, my lord, to decide the matter. It's not that we are biased, my lord, that we favor one party or not, my lord. It is for them, my lord, who want to prove the case, my lord. Our understanding about law, my lord, may not be 100% correct, my lord. But the allegation that he has leveled, my lord, on oath, my lord, that is very serious, my lord. Now, if I can show, my lord, if my lord can consider the affidavit, the written argument, my lord, that I have framed. Page 14. I have given. Page 14, if my lord may kindly come page 14, my lord. Now, the allegation was this: issues was never framed, my lord. The allegation was in the writ petition. If my lord goes to the writ petition, that issues was never framed. On the last date, my lord, he has argued on that. Now, this is the issue, my lord, that has been framed by the EM, my lord. Now, my lord, may kindly come to the order sheet, my lord, of the CEM code, my lord. Page number 18, my lord. Page number 18, my lord. If my lord may kindly consider the order dated 27/2/2020, my lord.
Yes.
CR put up today. Parties are present. The counsel of both the parties filed the written argument. Also had the submission of both the counsel. On perusal, their oral submission and written gist, the matter to be fixed for orders. That means for final order, my lord. Now, my lord may kindly see the next date. This was supposed to be on 26/3/2020, my lord. The next date. But on the next date, the matter could not have been proceeded, my lord, because of the COVID. Now, on 30th/9/2020,
Yes.
After the opening of the lockdown, my lord, the case could not be taken up due to the national-wide lockdown against the COVID-19 pandemic in India. Refix on 16/10/2020 for orders. Only for orders, my lord. Now, my lord, we kindly come to the next page, 16/10/2020. Case record put up today. Parties are present. Parties are present. The order is ready and pronounced in an open court. It is written on the separate sheet. Case 10 disposed of accordingly as to no cost, my lord. Now, on this 16/10, my lord, he was present before the court. And I have also enclosed, my lord, the final date or when the hearing took place on 27 February 2020, my lord, on page 21, my lord. If my lord may kindly come to page 21. Hazira on the above appellant are filed and represented by the counsel. Now, filed by Kennedy C.H. Marab and Jimbert Sangma. And my lord may kindly consider the affidavit, the Hazira has been signed by the advocate also, local counsel, my lord. How they can say, my lord, they have not been heard. And on this day, 27, my lord, the final argument was over. I have shown the order sheet, my lord.
May I reply you? May I reply you? He has stated on two things. He said framing has been issued. The framing has been, there was a framing, the issue has been framed. Issue has been framed means there is no conclusion.
What is submission?
No, I have every right to make my submission. It is not up to him to reject my submission. It is up to the court to decide and to hear. Yes, he can object.
Tell me, what do you want to say?
What I am trying to say is, the issue has been, suggested issue has been filed, but that there is not conclusion. There is no discussion on the issue framed by the parties, and it has to be conclusion. And after framing of issues, what we are supposed to do? When the issue has been framed, it has to be discussed detailedly. Whether this, and there should be a conclusion and finding. That was not there.
So evidence has to be recorded.
Yes. Then evidence has to be recorded. Just filing a suggestive issue, whether this, that is not the conclusion part. Secondly, my lord, I have till even today also, even from yesterday also, they have come to me. They said maybe that how can we will accept this new document, whether this is manipulated, whether this is bringing from the outside. But from my client, I have insisted time and again, I have asked them whether you have really appeared. If this document which they have enclosed to be corrected, how we will believe that can be?
It is not necessary for your client to appear.
Never. I'm strongly saying the court may state that.
Counsel will
yes,
to appear.
Yes, counsel may be, but now it will be the matter of evidence, because the client says he have never come, he has no knowledge, he have never signed, he have never filed the Hajira at that moment of time.
The counsel is appointed by you.
Yes. Yes, counsel is appointed by, but the Hajira is, it seems to be not filed. The counsel is filed by Kennedy C.H. Marab.
No.
Jimbat Sangma.
No, signed by the counsel.
And no, even by the client also, my lord.
No, the client is denying.
Okay, that
he
is
was not.
That is a different aspect.
Yes, that is a special one. But yes, that's why.
In 226, he will now request this honourable court to go into the handwritten. How it can be under 226, my lord? He is a petitioner. He should keep in mind. Second thing, my lord. Now let us see his writ petition. He is saying that he was not present on that day. His writ petition, the certified copy that he has enclosed, my lord, that is on page 65. And this is the petitioner documents, not district council documents that we have manufactured.
Yes.
My lord, may kindly see certificate copied issued by signature.
Page 65.
65, my lord. Annexure 9.
There's no page 65 here.
Annexure 9, my lord.
It is 59, my lord.
But in my page it is 65, my lord.
This is the order, impugn order.
This is the impugn order, 16/10/2022. 2020, my lord. So if on that day he was not present, my lord, then how can certified copy be issued to him, my lord, on this particular date? Do he has an answer for this, my lord? Now this also we have manipulated probably in his document also. That will be his counter to me, my lord.
But otherwise, let us speak otherwise, my lord. That 21/10/2030 is a letter issued by the advocate who was taken up the case.
So you file your
Yes, yes. Tomorrow, lordship, I'll file it. I'll file it.
Okay. When the matter was called up, Mr. P.D. Sangwan, learned counsel for the petitioner, has submitted that though a written argument has been filed on behalf of the petitioner, however, by virtue of this court's order dated 27/5/2024, the petitioner was allowed to file a supplementary written argument.
Lordship.
How the same could not be filed today due to personal difficulty.
Lordship.
Due to some personal, due to some technical problem faced by the learned counsel, it is prayed that the said supplementary written argument may be allowed to be filed tomorrow.
Lordship.
Mr. S. Dear, learned counsel for respondent number 3 has also submitted that he may be allowed to file his written argument tomorrow. Mr. S. D. SC JHADC has submitted that the relevant record as called for is now produced for this court.
I can submit it.
The same is duly acknowledged.
Right. Well, there will be no further hearing now because we have already submitted it. Only the written argument will be submitted.
Yes. Tomorrow.
Tomorrow
without fail,
will
lordship.
be okay.
Yes.
Or you want another date?
No, tomorrow I can file it. If not, then we can close it. I'm assuring before this, if my health condition, if there is no anything, then 100% I'll file it tomorrow.
100%.
No.
Otherwise, I can give you another month, 1 month or 2 months time.
Oh, your lordship, my clients in that they lived here, they have not bring my laptop also. Because
I'll give my laptop, my lord.
No, because the draft is there in my laptop. Just now
I know you should have been very clear with your facts.
No, it is actually very unfortunate. It should not happen this one. But then, what to do? After 1 week.
Now why it is 1 week?
No,
I have a serious objection.
No problem.
No, I have
1 or 2 days.
We are on 11 today. Friday.
Lordship. Friday. Lordship. Much blessed, lordship.
Tomorrow, on the next date, which I mean, on the next date fix.
Item number 13.
Yes, have you? I think Mr. Jha was here earlier.
Yes.
Have you talked to him? Yes, Mr. Jha, you were not here earlier. They had sought for judgment.
My lord, they have to provide me the copy.
Still waiting instruction.
The records have not yet been.
Okay, Your Honor.
Yes, and the counsel for the respondent has submitted that the records which are to be produced, relevant records which are to be produced before this court, has not yet been obtained from the department, and has therefore sought for some time for the same to be produced. The prayer not be objected to by the petitioner is hereby allowed.
2 weeks time may be given, Your Lordship.
This is matter of 2 weeks.
Highly obliged, Your Lordship.
Item number 14.
Lordship, this written argument is almost prepared. Only one or two paragraphs to be changes. So this matter may be listed after a week. Within a week, will be filing, Your Lordship, my written argument.
But you have also not filed.
My Lord, in fact, almost ready. Some correction here to be done, my Lord.
On pre-meet with parties, places matter after 1 week.
After 1 week.
Item number 17.
Here I prayed for some time, Lordship. I have been newly engaged in this. For the respondent number 7, Lordship. Yeah.
Who's respondent number 7?
Thatmanri, Lordship. Thatmanri village. So far as the main matter is concerned, I think pleadings are completed.
My lord, I filed a miscase. There is some additional miscase, my lord.
Oh, you said that in the meantime some land has been alienated.
Yes. My lord, may kindly
but
come.
Then the court's order is there, isn't it?
Court order is restraining me, my lord. But now,
you?
yes, my lord. Now taking advantage of this, my lord, they are taking out the boulders and they are selling it, my lord. They are destroying my pond.
Who's doing that?
It is the village Namdong, my lord. They are the petitioner. The petitioner.
Your Lordship, we just received copy today.
So, my lord, only to clarify, my lord, till the matter is finally decided by this one.
We should not.
Status quo, my lord. Because my lord may kindly see the pictures. This is very, because I have purchased this land. If
Yes, naturally. If suppose the case is decided in his favor, then what?
Then, my lord, it will be huge loss for me, my lord.
Your Lordship, maybe file a rejoinder regarding this.
Let him file a rejoinder, my lord, but my lord, let it be a status quo, my lord.
You file a rejoinder. So this order will be passed. Where's the miscase?
It's actually affidavit. They file.
Today we file it, my lord, the miscase.
You file by way of an affidavit.
Additional affidavit.
It's an additional affidavit, my lord. We have filed. Additional affidavit. And it is very disturbing if my lord kindly see page number 14. Annexure 3 in cities. These are the photographs, my lord. These are the coloring photographs. My lord may kindly see they are using the JCB, my lord. We have a video also CD, but we are not placing it, my lord. If required, you can place the CD also, my lord. It shows, my lord, they are selling trucks and trucks of boulders every day, my lord. And because of the order of this honorable court, my lord, I have been restrained. And whereas this land has been purchased by me, my lord, district council has acknowledged that, my lord. Even the Doloi has also acknowledged, my lord.
No, you see, you have been restrained.
Yes,
because the land was supposedly, purchased by you.
Yes.
So the issue of title is not decided here.
Yes.
So you still remain the owner.
Owner, yes, my lord.
So if certain attempt has been made to undertake this kind of work in your land,
yes, my lord.
It's incumbent upon you to also report the matter to the authorities concerned.
My lord, because the matter is pending before this honorable court, my lord. The Narthian police, my lord, they are not even accepting my FIR, my lord.
Your Lordship, if I may.
My lord, be kindly. Just my lord, status quo, my lord.
Yeah, it should be.
Status quo, my lord, may kindly see the cutting of the earth, my lord, and the boulders they are extracting.
Your Lordship, if I may, actually the respondent number 4 is actually claiming outside his pata. The pata is only regarding
These
a
cannot be
specific
decided,
area.
my lord. Now, how much area I have purchased or how much area the seller has sold to me, my lord, this they cannot object here before the honorable High Court, my lord. They are challenging my land documents, my lord. But this honorable court, as per my understanding, my lord, this petition is not maintainable because, my lord, they cannot. This honorable court,
Mr. Day,
my lord.
You say you have purchased the. If I
Land.
remember the facts correctly.
Yes.
You say you have purchased the land.
Yes, my lord.
There's also the land holding certificate in your favor.
Yes.
So I presume.
Yes.
There is a schedule of boundaries will be there.
Yes, my lord. Yes.
It's an excess.
So now,
yes,
if you see any such kind of work or activity is undertaken within that boundary,
yes,
then surely the court will come in your favor.
Yes.
But if these activities, as he has submitted, is outside
that is not correct, my lord.
your scheduled boundary, then you have no.
No, that is not correct. My friend, without any instruction, he is submitting because his statement, if it is recorded, he will be also in problem, my lord. this, because otherwise there was no question for me to file this additional affidavit, my lord. Only, my lord, that the documents which has been issued by the district council, the schedule of boundary is there, my lord. My lord may kindly pass an order that status quo in connection with that boundary, my lord.
Exactly.
Yes, if my lord pass that, my lord, I have no other objection, my lord.
If I may, your lordship, just from that pata, from one pata, the LHC issued was 4 numbers: 37, 38, 39, and 40 of 2022. So the land is in excess from that single pata, your lordship.
No, that you see, that issue will have to be decided.
That has to be decided.
Either by this court or by the trial court or whatever.
We have filed an affidavit challenging the maintainability of the petition.
That may come up in the due course of hearing.
Only, my lord, the patta which has been issued to me, my lord, the land holding certificate, there should not be any extraction or cutting of the earth, my lord, in that land, my lord, which I have purchased, my lord.
For more clarification, your lordship, if I may be allowed to file rejoinder regarding this.
Yes, please do.
On the meantime, my lord, let there be a status quo maintained by both the parties, my lord.
Heard, Mr. President, Learned Counsel for the respondent. Your respondent number?
I am for respondent number 4, my lord.
Respondent number 4. It is a submission of the Learned Counsel that in course of this proceeding, as far as the land allotted to the respondent 4 is concerned, this court, by order dated 6/12/2022, has directed that the respondent number 4, to restrain himself from any activities, for example, extraction from the land question. The Learned Counsel would submit that the respondent number 4 has complied with this said direction. However, the respondent number 4 has noticed that the petitioner
and his agent, my lord,
petitioner and his agent has intruded upon this said land in question and has extracted boulders from the said land, even using a JCB for that matter, for the said purpose. In such a situation, the Learned Counsel would submit that this court may direct the petitioner to refrain from such activities during pendency of this matter. Mr. Learned Counsel for the petitioner, in the meantime, has submitted that he has just received a copy of the said additional affidavit and would seek some time to file a rejoinder to the same. Pray aloud. However, pray aloud. On consideration of the submission made, though the petitioner is allowed to file the rejoinder to the said additional affidavit filed by the
Respondent
number 4. In the meantime, this court directs status quo to be maintained till further orders.
In connection with the land holding certificate number, if my lord may kindly give this also.
Okay. Status quo to be maintained in connection with the land
holding certificate number.
With the land
that
covered by land holding certificate number
38 of 2022.
38 of 2022.
Your Lordship.
39 of 2022. There are 4 land holding certificate, my lord, which are issued to me.
Your Lordship, if I may, those land holding certificates are in question.
No, that's
these are in question. That has to be decided.
That will be decided. In the meantime, see, this is
status quo be
this is an interim. This is an interim order.
Yes.
Only with regard to the activities.
Yes.
With regard to the those particular land.
Yes, my lord.
Because in due course it will be decided whether it will be in your favor or in their favor. But as of now, what is meant by status quo? As of now means till the dispute is resolved.
Yes.
No party is to undertake any activities.
Activities. Land holding certificate number 38, 39, 37 and 40 of 2022, my lord. 38, 39, 37 and 40 of 2022, issued by the Gentiles Autonomous District Council.
Now what about the what about the counter affidavit?
Counter affidavit has not been filed only by my.
I filed.
Yes. You have filed.
I filed.
Respondent number?
7 filed today.
So the matter can be posted for hearing, my lord.
You have all the
yes.
They have also filed rejoinder.
Except rejoinder for the additional affidavit and affidavit of number 7, Your Lordship, be filing.
The counter affidavit on behalf of all the respondents have been filed, except for respondent number 8, who will not file the who will not file the counter affidavit. The learned counsel for the petitioner has submitted that a rejoinder may be allowed to be filed against the counter affidavit filed by the respondent number 7. Pray aloud. This is matter for 2 weeks.
Hello.